Hey guys, before we get started, I wanted you to click on the link below to get a free copy of the Nevada Edge Guide. This guide is packed full of information about the benefits of Nevada LLCs and the tax strategies, all about using Nevada entities. Full of information that'll benefit you and your personal life. Just click the link below. Hello and welcome to another edition of Wealthy and Wise. I'm your host, Court Christie, CEO and founder of NCH, our sponsor today. Today we're going to be talking about real estate privacy trusts. Real estate privacy trusts, also sometimes called land trusts. And to break them down for me, I brought in the expert that we utilize here at NCH, who has supported so many of our clients. We have attorney Kurt Harris of the Harris Law Group. Welcome, Kurt.
Thank you. It's great to be here.
I'm glad you're here. And you always make it simple for our viewers and really help people understand what's behind, these different types of instruments or entities that we utilize, whether it's a corporation or an LLC or a trust or different types of trusts. And I think in this case with a real estate privacy trust, because we have so many clients that utilize those for holding their real estate investments. Let's unpackage that and let's start really broad as what is a real estate privacy trust, and who should use one?
Well, it is a super popular tool for the real estate investors, and we have found that it's good for anybody to use. And to kind of break down the nuts and bolts of what it is, in my opinion, I define it as a contract. It's a contract between the parties to the trust. And to any normal trust, everyday trust, there are three parties. There's the grantor, sometimes known as the settlor, that sets up the trust. There is the beneficiaries of the trust, those who are going to be receiving the proceeds or the benefits of the trust. And then finally we have our trustee, the person who's operating the trust and who is a trusted party to manage the assets in the trust for the benefit of the beneficiaries and in some times for the benefit of the grantor, if they've retained some interest in the trust. And so we have these three parties in the trust that are acting independently. And the beautiful thing about a revocable living trust, which is a real estate privacy trust, very similar to that, or a land trust, is that you can act as all three parties in that trust at any given time. And so it doesn't have to necessarily be three distinct parties, but it certainly can be. But in some cases, you can act as the same party as the trustee and the grantor, or also as a beneficiary of your own trust, because it is a revocable living trust. So those are kind of the three parties to any revocable living trust, and those are the names that they operate under.
Interesting. So you can be all three parties. Either you could be the grantor, the trustee, and the beneficiary of this trust to hold the piece of real estate. Are there times where you don't want to be each of those parties?
Yeah, in legal terms we call that, wearing separate hats. And there are sometimes it's difficult to wear two hats, or particularly very hard to wear three hats. And in a particular case with a real estate privacy trust, since we are trying to attain some level of privacy, it's a horrible idea to act both as the trustee and as the grantor. And so it would create some problems there where you would be acting in both capacities, and you could be deemed to be saying, well, you're just operating under an alter ego. You're just calling it a different name, but you're acting for your own benefit, and therefore it isn't really a real trust, or it's not really operating as a real trust, and you may lose some of the benefits of it. So in a particular case where you've got a real estate privacy trust, we recommend that you not act in those two capacities, and that you get another individual who's independent to act as your trustee. It's not required, but you really should do it. It's best practice. In addition to that, generally you may want to list yourself as a beneficiary and others if you'd like, or you could list just yourself. It's probably not as well recommended. You might want to have other parties to be the beneficiaries. Should something happen to you, should you pass away or something, you can pass it on to the next generation. And so, but you can act in all three capacities. Not recommended under a real estate privacy trust to act as your own trustee.
Now this is actually a recorded instrument, right? As far as the piece of real estate that is purchased and put into or in the name of this real estate privacy trust, that ends up in your recorded deed, I believe. Is that how it is?
Yeah, it'll end up in the deed. The name of the trust will be the party that is really the holder of the trust. I liken it to like a basket. It's a basket that's holding a deed, and the trustee has their hand on the basket, and they're holding on to that for you, for your benefit of what's the contents of the basket. And so your deed will read something like the property is, the Rusty Spur Trust, or it's held by, Kurt Harris as trustee of the Rusty Spur Trust. It depends on what your jurisdiction is as to how they title it, but that is on the deed, and generally the owner's name would not be on that deed anywhere. And so you wouldn't know who the owner was, nor would you know who the beneficiaries were, who's going to receive the benefits of the trust. You would just know the name of the trust and perhaps the trustee of the trust.
So we'll talk about some of the whys behind why you'd utilize a real estate privacy trust here in a second, because there's a couple different benefits, but let's focus in on the name of it. Real estate privacy trust, okay? It's private. What does that mean when we say it's a private trust?
Well, it's not recorded per se with the county. So it's like I said before, it's like a contract between you and the parties.
So like an LLC is registered at the state. You've got the name of the people involved at the state wherever it's registered to do business. So in the case of this trust, it's not registered anywhere.
It would not be registered, and it would not be recorded. And you probably wouldn't even want to show it to anybody, to even show them the contents. You're not required to do that. You'll see the name of it on public record or on the deed, but the contents of the trust would not be disclosed. And so that's where you get the real estate privacy portion of this. So I can say whatever I want to in my own private personal trust, and that doesn't need to be disclosed to any party per se. And so I don't have to disclose who my beneficiaries are, and my beneficiaries may not even know who they are, and they probably shouldn't. If it's my children or something like that, they don't even need to know. So I keep all that private, all that confidential, and I keep that as my own personal record and not for any other party.
So the contract, the real estate privacy trust, not registered anywhere. However, if I'm buying a piece of real estate, now the name of the real estate privacy trust, you said the Rusty Spur Trust, would be listed and recorded in the county where that property is held. Is that right?
That's correct. Yes, it would be recorded there.
So for the privacy portion to kick in, there's one thing that I know that's really important with this is, the Rusty Spur Trust is now named as the owner of that property in the county where you are, and anyone can go on the county recorder's office and see who owns that property. And they're going to see the Rusty, you said Spur, right?
Yes.
The Rusty Spur. And so, but also, there's a person listed, is that right?
In some jurisdictions, they require that you also list the trustee of the trust.
Okay.
Not all jurisdictions, but in many.
Do you find it's most of them, half of them?
I think it's about 50-50. And the problem is that there's like 3,500 counties in the United States. And so it's hard to track all of them. And we've covered a lot of them. I would say we probably have a pretty good grip on more than 1,000 that we've had trusts in that many jurisdictions. And it's up in the air. It's split 50-50.
So really to gain the privacy element of the real estate privacy trust, we'll talk more about the benefit of privacy in your financial affairs here in a minute, but you would not want to be the trustee of your own trust. Is that right?
To some degree, you're probably defeating your own purpose,
right?
Because then now you're the trustee of your own trust. That still doesn't tell me you're the owner, but I'm probably suspicious that you probably know the owner, or maybe you are the owner and you're acting like an owner, or I have some other information or evidence out there that leads me to believe that you are the owner of the trust. And so it's best to put somebody else on there, preferably not your last name. Preferably somebody who, it could be a brother-in-law or somebody like that, or a sister-in-law that maybe doesn't have your same name, whatever the case might be, I'm not sure, because that would be more ideal. It wouldn't point it directly at me, which is what we are trying to avoid here.
What's interesting about that is you could use a family member, like you said, with a different last name, so you still have some privacy in there. But you might get, some viewers thinking, well, I don't know who I would use in my family, and I probably wouldn't want to put them out, or maybe I don't think that's the right position for them or role, or I don't trust them, okay? What other alternatives are there for putting another person or name on as trustee other than family members?
Your best alternative at that point is to get a service, a real estate trustee type service to serve as your trustee. And in some cases, I think that the client or the customer, I really want you to know more about my story. I want to tell you more about who I am and what I am. And in some cases, your paid service, it's best that they not know that. And in some cases, it's best that they remain ignorant to some degree as to who you are. Because the less they know, the less they can share, or the less they can be compelled to say. So you may not want them to know anything other than, here is the trust, your name is on the trust, do what the trust says. And don't do anything else. Read the contents of the trust, follow the trust. You don't need to know who I am. And should something ever happen to me, make sure that this property gets to my beneficiaries, to my children, or to those that I've designated, or to my charity, or whatever the case might be. Just follow the rules of the trust. You don't need to know anything else. And in some cases, that's ideal. It's ideal for the trustee, and it's ideal for you, should any questions ever be asked of the trustee.
That makes sense. So where do they find a service like this where if they're looking for a professional trustee?
Well, NCH certainly offers one, I know, and I think that a lot of law firms potentially could do that, and there are other trust companies that provide this type of service, but sometimes they'll say, well, we don't want to deal with it unless the estate is really a high value or a high dollar estate. We don't want to nickel and dime with a single property or a double property, because they're really looking to get paid based upon the percentage of the overall estate should something happen to you. So if you're looking for a bank or a trust company, they're probably going to want a lot of money to do it. Whereas you might be able to get an individual or a service like NCH offers that does it very reasonably, but you're not going to get a whole ton of interaction with them either. They're there to serve as a figurehead and to receive mail for you or other information, and not really be an active trustee.
And the only thing you would need from that trustee then is, maybe they have to sign a document once in a while. If there's a transaction that occurs with the trust, then they may have to be the name on it for the final disposition of the asset. Is that right?
That happens occasionally. Yeah, there might be some refinance information, or that trustee may need to sign the sale documents, or some other documents may come across their desk. It's pretty minimal things, though. As we all know, when you're holding property, there's not a lot to be done, especially passive holding of rental property and things like that. There's not a lot of things for your trustee to be engaged in. You may want to have an operations company that handles the rents and things like that.
That makes sense. Okay, so it's pretty straightforward. I mean, you use a real estate privacy trust to position yourself to have some privacy in your holdings, what you own, and you can use a professional service or a family member that, if your county requires the name of the trustee, you eliminate a little bit of the privacy of the trust if your name's on it. Therefore, use a family member with a different last name is just one way to create a little privacy, or use a professional trust company, which NCH has a service like that to allow you to maintain the privacy of the trust itself.
Absolutely.
Okay,
yeah.
Makes sense. So let's talk about privacy then. Why are we even talking about a trust that's special, that has privacy? Why is privacy important?
Well, I think it's super important for a lot of reasons, and that is that there's just a lot of snoops out there, and there's a lot of people that want to know what you own. When you are holding a real property that you're renting, it is susceptible to a lawsuit. Generally, that lawsuit's going to come from your tenant for some undisclosed or some problem that's potentially on the property, or some guest that comes to the property. So you could potentially be brought into a lawsuit on that. For other reasons, if there are other lawsuits that are out there being filed for other reasons, oftentimes the attorneys, we go on the assessor's website for the county where we reside, and we look to see what kind of property this person owns, and if they do own property, or the surrounding areas. And that gives us an idea about whether or not they're holding assets, and whether or not a lawsuit can be filed And if we could get some leverage on somebody, somebody that got something to lose, puts themselves into a certain position where they become a little more appealing for a potential lawsuit on an unrelated matter that may not have anything to do with the property. But now I know, hey, this person owns a certain amount of real estate. This is a person that really cares and is concerned about their assets. And that's someone that might be appealing for a potential lawsuit. And you're able to go back to the client and tell them, yeah, this is a significant asset holder. This is someone that has something to lose. So, this might be a more worthwhile suit than, say, someone where somebody doesn't.
That's interesting. So, for all of our viewers here, Kurt is one of the good guys. However, he's pointing out that one of the things that if somebody's thinking about suing you, they would hire an attorney to file the suit, and the attorney would help them identify whether or not the person that you're suing is worthwhile going after. You don't want to sue a broke deadbeat. Right? That doesn't serve you any good. You might find out that there's some insurance involved, therefore you always find an attorney, to go after an insurance company, but sometimes insurance isn't enough, or in some cases these aren't insurable things. And now we're talking about going after the owner of the property. And if the owner looks like they own nothing, they're a lot less appealing to want to sue and spend a bunch of time on. No offense to people in your profession, but most are very happy to take a check from somebody and file a lawsuit. But some people can't afford to write the check for the lawsuit, and therefore they might go to an attorney and say, can you take my case on? And that means essentially, I don't expect to pay you. You will work towards getting me money and we will split the proceeds of the lawsuit. Is that right?
Yeah, and in some cases, really the insurance money is the low-hanging fruit. And so if there is an insurance policy there, many plaintiffs' attorneys will say, that's great, that's good. But also there's like this new kind of trend where I'm also looking at the owner. And I'm saying, well, look, here's the deal. There is the low-hanging fruit out there that I'm going to go after the insurance policy and the proceeds. But I also want to squeeze you as the owner too, since I know you have something to lose and I know you've got property there. So why not just give me $20,000 in addition to the insurance proceeds to help me go away? And so now I'm going to try and squeeze that owner personally, despite the fact that they've got insurance coverage, but I still can drag you into the suit and just try to make life miserable on you. In an effort to try and maximize more money for my client's recovery and for my ultimate recovery, because now I've got a piece of the pie because I'm on a contingency. And so knowing who the owner is gives me a little more information, a little more leverage that I might be able to have, because I can now squeeze that owner. If it's in a trust, I don't know. I don't know who owns it. I don't know what the situation is. And I'm not really putting a squeeze on this person because now I perceive them to be a little more savvy investor. Despite the fact I may have an idea that they are the owner, now I know they're a savvy investor, and now I know that I'm going to have a little bit of a fight before I get them, and they may not be as eager to get a few dollars squeezed out of them.
And there's going to be some unpackaging to get through this process.
It's going to cost.
It's interesting, 30 years ago when I got into helping people register businesses and helping investors protect their assets, I learned from a gentleman who was in Florida, and he must have had about 500 rental homes, but no one knew he owned one of them. And he found for himself, he was a very wealthy, very successful investor, but he found his life was more peaceful when everyone thought he owned nothing. And he was a master at this. In fact, you could say it was an obsession of his to look and act like a pauper. Even the car he drove was something way beneath his means. But I learned a lot from him because he lived a very peaceful, enjoyable life without having to show anyone what he actually had for wealth. And he did that, most of it, by using business structures and trusts together to lower his profile so his name appeared nowhere. So literally when he'd show up at his properties, he'd show up as possibly the property manager, possibly a maintenance person. He'd go by and check on things, but no one could tell by how he dressed or what he drove that he was the owner of the property. And he found that was the best thing ever for litigation, lowering the exposure overall, which was quite wonderful. And this is kind of the advanced of what he taught me 30 years ago that you're teaching us right now, is that privacy really matters in today's world. And we generally refer to it as financial privacy because some people think privacy is a bad thing, like you're trying to hide something. We're not trying to hide anything here. We're trying to give you some financial privacy to lower your exposure to lawsuits, for one, and just snoopy people. I have neighbors who, have talked to me about other neighbors, and it's very funny. They'll say, oh yeah, they own a bunch of land over here. I'm like, how do you know they own a bunch of land over there? Oh, because I pulled them up on the county recorder. And I'm like, who does that? They just wanted to know about the neighbors, and so they decided to go online and start pulling their name up and seeing what they have and what's out there. And it was shocking to me, but there's a lot of people that do that. And then they spread gossip or whatever else, or in the case of an attorney, as you said, they do a simple asset search. They can pull up, what does Court Christie own? Oh, well, let's pull it up. Oh, I see his name here, I see his name there, but if I've done it right, doesn't look like he has much. Maybe we don't want to go after him. Very different scenario. So privacy is very valuable, and I think it's undervalued in today's world. But if you have anything to lose, I'm going to say financial privacy matters. And it really matters in our litigious society that we have. And that's where, the Real Estate Privacy Trust fits in. Now, before we close it out, real estate privacy trusts, most often with our clients, aren't just a standalone. They're also working more with their LLC that they own in connection with running the business of owning real estate. Can you explain to me how they work together?
Yeah, at some point, you hope, if you're just going to have one rental property, maybe you don't need to follow kind of the standard model that we like to promote, and you can just hold it in that particular trust. But if you get a couple of properties, we recommend you put it into a couple of trusts and you use separate names, whatever you choose or whatever you'd like to do. And that you use an LLC in conjunction with those, a limited liability company. And if you set up that limited liability company to receive the rents from the trusts, from those properties, or to be kind of that property manager, then you are able to build in some limited liability in between yourself and those trusts. And so here in Nevada and some other jurisdictions, we have this charging order protection, which it says that you can only get money out of the profits of that LLC. And as you funnel all of your rents into that LLC, that LLC is also paying for certain repairs on the building and a few things like that. And you're able to maintain those profits in that LLC and to give yourself some limited liability and exposure to those properties. And so we like to set that up. Ultimately, we like to see have 5 to 10 different rental properties, all feeding into a single limited liability company, and you still have that limited liability protection, and you still have the privacy offered at each level of every property with the Real Estate Privacy Trust. And we think that to be somewhat ideal in managing and holding your property, keeping yourself safe from any potential suits.
All right, well, thank you so much, Kurt, for giving us this wonderful insight. And then, finally, how to put an LLC and a real estate privacy trust together. And I think the important thing for our viewers, is to understand that each person's situation is unique. So if you own real estate right now, you might want to put it into a real estate privacy trust. Or if you're thinking about buying real estate, you probably want to buy it in the name of a real estate privacy trust. But to understand how the business entity, the LLC, works in conjunction with this holding entity, the Real Estate Privacy Trust, is where the conversation should take place. And I encourage all of our viewers here to call NCH and find out more in your situation on exactly how you can take advantage of having financial privacy for your real estate investments. Talk to one of our consultants. There's no obligation. They're there talking to people all day long about how they might put a structure like this in place and why they would. And oftentimes there's nuances where everybody's different. And so that comes up in conversation. So I think it's real important that people have a consultation and they can understand exactly how it fits into their world, their investments that they're involved with. So that I always want to encourage everybody. So Kurt, thanks for being on the program today.
Thank you.
Yeah, this is wonderful. This is good content. Everyone, thanks for tuning in to another edition of Wealthy and Wise. I'm your host, Court Christie. It's been a pleasure.